I'd like to bring this meeting to order. This is meeting number 24, the Standing Committee on Public Safety and National Security. And we are dealing with Standing Order 108-2, a study of the report of the Commission of Inquiry onto the events relating to Mahar Arar. And we would like to welcome our witness this morning, the Commissioner of the Royal Canadian Mounted Police, Mr. Zaccardelli. Welcome to the committee. We appreciate you coming before us today.
Point of order.
Point of order.
Mr. Chairman, further to pages 861 and 862 in Marlowe and Montpetit, I would ask that the witness be sworn in.
Okay. Does the committee consent to that? Any objections? Okay, we will have the witness sworn in. Go ahead, sir.
Shall give on this examination shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. Okay, we'll ask the cameras to withdraw. Yeah. We'll ask the cameras to please withdraw at this point. We'll just pause a moment while they clear the room. We usually allow an opening statement of approximately 10 minutes, whatever you need, and then we'll open it up to questions beginning with the Liberal Party. So when you're ready, you may begin.
Well, thank you, Mr. Chairman. Good morning, ladies and gentlemen. Bonjour, mesdames et messieurs. Je suis heureux d'être ici aujourd'hui.
Good morning, ladies and gentlemen. I am glad to be here this morning and to have the opportunity to review and discuss with you a number of matters arising from my appearance here in September to discuss Justice O'Connor's report of the events relating to Mahar Arar.
My last appearance before this committee occurred, as you know, within a fairly short time of the release of the report. I know that the committee shared my desire to hear the response of the RCMP as soon as possible, and I personally believed it was important to extend an apology to Mr. Arar and his family without delay. I also looked forward to sharing with the committee details on the important work of that the RCMP is doing to implement the recommendations. As a result, I believe some aspects of my prior testimony could have been more precise or clearly stated. A number of misconceptions have resulted, and as I indicated in my letter to the committee, I have been anxiously awaiting the opportunity to set the record straight, both for the committee and for the Canadian public. At this point, I believe it would be helpful for me to outline a number of key facts, including what I personally knew and when, what was included in ministerial and other briefings, and the matter of our organizational response. Le rapport du juge O'Connor dresse ainsi la liste.
The following facts are itemized and confirmed within Justice O'Connor's report.
Legitimately identified as a person of interest in the post-9/11 RCMP counterterrorism investigation known as Project AO Canada. At that time, Mr. Arar and Ms. Mazig, as part of a request to U.S. and Customs, were included in a list that resulted in them being inaccurately described as Islamic extremist individuals suspected of being linked to the Al-Qaeda terrorist movement. Par la suite, Monsieur Arar.
After this, Mr. Arar moved in and out of the United States on 2 occasions prior to his arrest without incident. And indeed, Justice O'Connor concludes that, above all, he could not ascertain with any certainty what steps, if any, were taken by the Americans as the result of the request.
That Justice O'Connor states senior officers were generally aware that the U.S. Customs request had been made, but not of its specifics. Nor, I can tell you, would they ever receive that level of detail in the reporting relationship. In the spring of 2002, RCMP shared information with their American counterparts in the form of 3 CDs containing extensive documentary information collected during the investigation to date. 94 of these documents made reference to Mr. Arar, and some inaccurate factual information was later found in them by Justice O'Connor. In July, Project AO Canada learned that Mr. Arar and his family had left for Canada for Tunisia. The investigators later referred to this departure as sudden. They also characterized the conditions placed by Mr. Arar's lawyer on an interview as a refusal. Justice O'Connor found that these were 2 instances that contributed to an incorrect and potentially inflammatory picture of Mr. Arar. However, during this time period, there was no recognition within Project AO Canada that such an incorrect portrayal was emerging. In September 2002, Mr. Arar was detained by American authorities while traveling through New York. In discussions with the Americans at this time, RCMP were clear that Mr. Arar could not be linked to al-Qaeda. They informed their U.S. colleagues of this in both written and personal communications. Staff involved were consistent in their approach and continued to tell the Americans that the RCMP had no basis to detain Mr. Arar, to charge him with a criminal offense, or to prevent him from re-entering Canada. On October 5 and 7, respectively, RCMP staff advised the FBI that the RCMP could not link Mr. Arar to al-Qaeda. And here, Mr. Chairman, I will refer to my letter that I sent to the committee on November the 2nd. And in the letter I state, nevertheless, the fact remains that RCMP investigators clearly informed U.S. officials that there was no evidence to support criminal charges against Mr. Arar in Canada, that he could not be prevented from entering Canada, and that we were unable to link him to al-Qaeda. This should have had the effect of correcting any inaccurate information that had been provided previously. When I stated on September 28, 2006, that we had corrected the record, this is what I was referring to. While my remarks could have perhaps been clearer, I think Mr. Easter recognized the unfounded basis for some of the committee's questions when he cautioned against reading too much into what I had said. On October 11, 2001, I was formally briefed that Mr. Arar had been removed to Syria by U.S. authorities, that the RCMP had shared our investigative material with them, and that Mr. Arar was considered to be a person of interest. Là encore, comme l'affaire...
Again, as Justice O'Connor clearly states, it is important to reiterate that no senior staff, including myself, were told of the inaccuracies in the information provided to the Americans.
Over the fall of 2002 and spring and summer of 2003, the RCMP continued to interact with Canadian agencies such as PCEPC, DFATE, CSIS, and PCO to ensure ministers were appropriately briefed of the circumstances relating to Mr. Arar. Deputy Commissioner Gary Lepke was the primary lead for the RCMP. When representing the RCMP at numerous and regular interdepartmental meetings, he expressed what was known to us at the time, that the RCMP had shared investigative material with the U.S., that the RCMP had told U.S. officials it could not charge Arar criminally or refuse his entry into Canada, and that the RCMP could not indicate links to al-Qaeda. Deputy Commissioner Lepke periodically and regularly briefed me, and Minister Easter was also briefed regarding the situation as I have described. Specifically, in November 2003, Minister Easter was given a comprehensive operational briefing which included that Mr. Arar was deported to Syria unilaterally by American authorities, that the RCMP had shared investigative information, that Mr. Arar remained a person of interest. I think it is important to note that for the RCMP, Mr. Arar remained a person of interest during the whole period I have outlined. This is what I knew, all that I knew, during the 3 years from Mr. Arar's deportation until the release of Justice O'Connor's report. On this key question of what was known by whom and when, I think it is helpful to reiterate two statements from Justice O'Connor's report. The first statement, with regard to the inaccurate information that was contained in the 2001 U.S. customer request, Justice O'Connor states, senior officers were not appraised of the fact that Project AO Canada had described Mr. Arar and Ms. Mazig as Islamic extremists in its border lookout request to U.S. Customs. Second, with regard to the questions RCMP sent to American authorities while Mr. Arar was detained in New York, he states, I note that senior officials at A Division and in the CID were unaware that communication was being sent. It was during the inquiry that the compilation of all facts related to the events surrounding Mr. Arar was painstakingly pieced together by Justice O'Connor. But it is important to remember that Justice O'Connor confirms what I too believe, that no bad faith could be attributed to members of Project AO Canada. This is made even more evident by the fact that Project AO Canada staff did not identify or report any inaccuracies to senior staff, believing that any information used by the U.S. would be verified and that Mr. Arar would be subject to due process as is standard operating procedure for police. As I've noted before, the decisions made by senior officers, which I support, has been to accept these problems at an institutional level and to put into place corrective measures that focus on, first, strong central governance, second, information sharing, third, extensive training, fourth, effective integration. Such measures are designed to increase our organizational effectiveness in the very challenging arena of national security and terrorism, and to ensure that similar problems never reoccur. As former Deputy Prime Minister and Minister of Public Safety, Anne McClellan told this committee just last week, accountability takes on many forms, and we have to get past the notion that heads must roll to have accountability. Sometimes maybe they should. It may also mean that you change the procedures that you had in place that led to the mistake to make sure it doesn't happen again. In other cases, it will be something else, perhaps something more important in terms of the culture of the organization. Mr. Chairman, I want to be very clear about the significance of what I have said here today. For a government official, nothing is more fundamental than ensuring that the information they provide to ministers is accurate and complete. To improperly withhold information or to misrepresent facts is a cardinal sin. If I had been guilty of such actions, no one would have to ask for my resignation, Mr. Chairman. The facts of the matter are, however, that due to circumstances I have described, we were unaware of some important information until the completion of Justice O'Connor's inquiry this year. My colleagues and I deeply regret that mistakes were made, but it is important to recognize that at all times we acted in good faith. Finally, before we move to questions, I would like to thank you for giving me this opportunity to speak with you today. As I stated on September 28th, it is just such steps that assure all Canadians of the existence of transparent, accountable, and responsible leadership within the Canadian democratic system that is the very bedrock of a safe and civil society. Thank you. Merci.
Thank you very much, Commissioner Zaccardelli. And as is the usual practice at this committee, we begin with questioning, a 7-minute round. All political parties participate, beginning with the official opposition. Mr. Holland, I believe you have some questions for the Commissioner. Go ahead, sir.
Thank you, Mr. Chairman. Thank you, Mr. Zaccardelli, for coming before the committee today. I'd like to start with a quote from September 28th. The quote is, "I found out that investigators were speaking with American officials while he was in detention," he being Maher Arar. "I learned that in this process they tried to correct what was labeled as false or incorrect information with regard to Mr. Arar. That was my first point of knowledge in the matter." Now, this wasn't one reference. We count 8 separate references saying precisely the same thing, stating that your first point of knowledge of this matter was much, much earlier than you are saying today. I'm wondering, because you are now saying today that you were in the dark, that you didn't know anything until Justice O'Connor's report came forward, that on which day you perjured yourself before this committee, today or September 28th?
Mr. Holland, you know, I first had an opportunity to read Justice O'Connor's report when I returned from overseas. As soon as I received the 1,200-page report, I immersed myself in that report, and I tried to come before the committee as quickly as I could, and we had contacts with the committee. So I tried to get as much of the facts as I possibly could. I have to honestly tell you that in preparation for coming here in 28th of September, I thought I was preparing myself to deal mainly with the recommendations in the way forward. When I came here and testified, I gave the best answers to the best knowledge that I had at the time. Subsequent to my testimony, in reviewing my testimony and hearing comments, I realized that some of my testimony and my comments were not as precise as they possibly could have been. And that is why I did everything I could to try to get back before the committee to correct the record. The information I gave on the 28th was the best information I had. The first time that I became aware of this matter was in 2002, after Mr. Arar is in Syria and it becomes very public. It is then that I start to inform myself. That's the first time that I started.
Let me say, on the basis of what you said today, on the basis of what you said on September 28th, there really are 2 conclusions that one could draw, depending upon which version we're going to take, which version of what you put before the committee we're going to take. One, that you knew nearly from the beginning, and that you did very little. And to be honest, when we go through the testimony and we hear what both you said and then subsequently what information that we obtained from Shirley Heafy, who was the former RCMP Public Complaints Commissioner, who stated that the RCMP stonewalled her when she was trying to get information about national security cases. She's on record as saying that the RCMP's direct refusals to release files for investigation of public complaints was an attempt to frustrate the complaints process.
Lindsay, you have a point of order?
She never appeared before us as a witness.
I didn't say she did. I said that Ms. Heafy, in reviewing the information and information that I was able to get, I found these statements.
I think you need to make that more clear then, because I think that...
No, she never appeared before this committee, but these are statements of Ms. Heafy, who is the RCMP Public Relations Commissioner. Just let me finish, because this is important. The second conclusion, if we are to accept, and I find it extremely hard to accept the second possibility, that you were in the dark, that you knew nothing, that as head of the RCMP, you were so out of touch with your organization that you had no idea what was going on and weren't asking questions in that period of time. Both are unacceptable, and frankly, to be honest with you, one way or the other, you either misled or did not tell the truth before this committee. And really, the question is no longer whether or not you should be fired, Mr. Zaccardelli. In my opinion, it's not. That has been made clear today. The question is why the government, why Minister Day and Prime Minister Harper went to such extraordinary lengths to protect you. What I want to know is in the 10 days intervening between September 18th, when the report was released, when the O'Connor report was released, to September 28th, what happened? The meetings that took place, the discussions that occurred. And this is what I want to get to, because I don't understand. When we had Minister Day before this committee, he said that the Prime Minister and Minister Day stood 100% behind you. Now, we reserved judgment. We waited and listened, and we said, let's make sure we get everything in front of us before. They didn't. They said immediately, despite all the contradictions, despite all of the problems, despite every reason in the universe, to at least take a pause and ask some questions. They asked none. It was left to us on this side, all of the opposition parties, to ask questions. So let me go to that intervening period of time. When you appeared before this committee, in that time that I'm referring to, between September 28th until the 18th to the 28th of December, can you tell us if you met with Minister Day? If so, what was the content of that meeting? What was discussed? And if there was any discussion around a communication strategy of how to deal with it.
Mr. Chairman, out of all of that, there are two questions that I want to address. First of all, as I said in my statement, I want to be very, very clear. And Justice O'Connor states in his report, no senior officer was aware of any of the errors and mistakes and mislabeling of Mr. Arar in the report. I would like to finish my answer, Mr. Chairman. No, Mr. O'Connor states that in his report very clearly. I and my senior officers became aware of the errors and mislabeling at the conclusion of Justice O'Connor's report. It is only Justice O'Connor who takes all these various elements of the mistakes and the mislabeling, who brings it together as an auditor, examining these, and brings it together and comes to this conclusion. That's the first time that it is all brought together. And in his report, he states very clearly, no senior officer was aware of that. In my testimony on the 28th of September, I clearly inferred that some of the knowledge that I got when I read the report, I implied that I may have had it in 2002. That was a mistake on my part, and that's why I wanted to come back here to correct the record. But that is very clear, and it's important for the committee to understand that. No senior officer was aware of it, and all of us became aware after the report was published by Justice O'Connor. In respect to the second question that Mr. Holland raised, I will go to the point of my discussions with the minister relative to the so-called muzzling, as you called it the last time I appeared, Mr. Holland. Mr. Chairman, the report was issued on the 18th of September. I was overseas. I was in Brazil at the Interpol conference. When the matter broke, that was on the Monday that the report was issued. I came back on the late Wednesday afternoon. I went to my office, I changed, and I went and met with the minister. I met with Minister Day. We had a discussion about the report. He asked me if I read the report. I told him I had just gotten the report, and I was in the process of trying to read it. I had not slept because I'd flown all night. He said, you should get some sleep. That's what I did. I read the report, and then the next morning, I was in my office, and I got the first indication that this committee might be meeting. So I called the minister's office and I set up a meeting. At the same time that day, I wrote a letter to the minister indicating my desire to appear before the committee and to make a public response to the report. We met the next day. Minister, or Mr. Chairman, and on Thursday, that was when I wrote the letter, and I had the discussion, and I heard that the committee might be meeting. On Friday, I met with the minister. The minister and I discussed the report, and we discussed the possibility of the meeting. By Friday afternoon, we had indication that the committee would be meeting on Tuesday. We both agreed that's the ideal time and the ideal place to have my first appearance. That's exactly what happened. That's what transpired between the minister and I. At no time, Mr. Chairman, was I ever directed, was I ever given any instructions, was I ever sent any indication that I was not to speak or not to talk about it. We understood that this committee was to meet as soon as possible, and we agreed this was the proper place to explain what happened.
Menard, 7 minutes.
Merci, Monsieur le Commissaire.
Thank you, Mr. Chairman. Mr. Commissioner, I'd like to ask you a simple question. What should a police officer do when he realizes that an innocent man is in jail because of an error, probably because of an error committed by one of his subordinates?
This is an interesting question, Mr. Chairman, because if one reads the report and is aware of the report, Mr. Arar was a person of interest from the moment he came into this file. He maintains that designation in the investigation. And again, I go to Justice O'Connor. He was a person of interest before he was detained in New York. He continued to be a person of interest when he's in Syria. He continues to be a person of interest until Justice O'Connor issues his report that says that he was not involved in any criminal activity or not involved in any terrorist activity. Mr. Arar was always considered a person of interest, and Justice O'Connor states that, and that's why he supports that the investigation by the RCMP was legitimate and we were entitled to pursue that investigation. He was always a person of interest, Mr. Menard.
Monsieur le Commissaire, je ne crois pas que vous avez répondu.
Mr. Commissioner, I don't think you've responded to my question, but because we have so little time, I will accept that answer, because no answer whatsoever is still an answer. I understand. But I asked you for the first time when you yourself became convinced that Mr. Arar was innocent of any kind of links with a terrorist organization, and you stated, as I heard you respond to Mr. Cutler, as soon as he was sent to Syria and imprisoned, I became aware of this case, and then I maintained that, and that's when I had that conviction. Do you still maintain that point?
I want to clarify that matter. As I said, I am here to clarify any misinformation that I may have provided inadvertently. I learned of Mr. Arar and of the errors that were made related to him and the mislabeling of Mr. Arar once Justice O'Connor issues his report. And Justice O'Connor supports that because he says that is when senior officers were not aware of those mistakes and that mislabeling. And I apologize if I in any way gave the wrong impression when I testified the first time. But that is what I want to clarify here today.
All right, I understand. You must acknowledge that that is certainly not what we had understood the first time you appeared before us. I understand that, and that is why I wanted to clarify the situation here today. Wouldn't it have been a better opportunity, in fact, to correct? Well, you understood full well that I was convinced through my questioning that you knew that Mr. Arar was an innocent man, that he was not linked to terrorist organizations when he was being detained in Syria at the time. When I asked you this question, Mr. Zaccardelli, as soon as you knew that Mr. Arar was in Syria, you had the case pulled out, and you knew that it was because of a mistake from the RCMP that he ended up in this prison in Syria, languishing there. Most Canadians believe that before the O'Connor Commission report was out, that Mr. Arar was in some way related to these terrorist activities, although it was false information. I asked you, how could you not have found some way to personally inform the minister of this? And finally, why did you not do everything in your power to make sure that Mr. Arar be freed and cleared of these accusations? Would that not have been a good opportunity, Mr. Zaccardelli, if the version you're giving us this morning is the accurate version, to correct the impression that we were all under, that you knew when Mr. Arar was being detained in Syrian prisons that he was innocent of any link, and that in fact he was in one of the worst prisons in the world?
Mr. Chairman, again, I go back to my previous answer. I tried to inform myself as best I could from reading the report. I wanted to appear as quickly as possible. I've indicated that I may have not totally represented the facts as they were, but Justice O'Connor in his report very clearly states no senior officers were aware of these mistakes or this mislabeling. None of us were. We only found out after Justice O'Connor brings all those together through his exhaustive analysis. And I use the analogy of an audit, Mr. Chairman. An audit often goes into a large organization and takes disparate pieces of information and brings them together, and then we can see the picture. Mr. Arar was neither innocent or guilty for us. He was a person of interest from the beginning right till the end of the report. And again, Justice O'Connor states we had every right to consider him a person of interest throughout this ordeal. And that's what I've tried to clarify here today.
Monsieur Zaccardelli, oui ou non?
Mr. Zaccardelli, a yes or no answer. Did you know when Mr. Arar was in jail in Syria, first, that he was innocent of any kind of relationship with terrorist organizations, and second, that most probably it was due to errors communicated by the RCMP to American authorities that he had been sent to one of the worst jails in the world?
For us, Mr. Arar was always a person of interest. I did not learn about the mislabeling or the mistakes until after the conclusion of Justice O'Connor's report. Therefore, I could not have known that when he was detained in the United States or when he was detained in Syria. I only learned of that mislabeling after the conclusion of the report.
Alors pourquoi m'avez-vous pas corrigé quand je vous ai posé cette question?
So why did you not correct me when I asked you this question last time around?
Go ahead.
Again, I've stated if I was incorrect or if I wasn't as precise as I should have been, I'm here to correct that mistake. I accept that I may have made a mistake in some of my answers, and I look forward to correct that ever since I learned about that when the media started to report some of this, and the clerk knows that my office tried to get a hold of the clerk to come back. I wrote to the committee, Mr. Chairman, to get back here as soon as I could. I did everything I could once I realized that I possibly had not been as precise as possible in my testimony.
Thank you, sir. Mr. Comartin, for 7 minutes, please.
Thank you, Mr. Chair. Thank you, Commissioner, for being here. But I have to say to you, in the letter to us, you said something about, well, there was a misperception of your evidence when you came the first time, and you're repeating that today. And I practiced law in the courts for 27 years, and I've read this transcript of your testimony. I've read it a number of times, Commissioner. In response to 4 different members, Mr. Kotler on the second occasion, you repeated over and over again that you knew, and the upper level of the officials, the upper level of the RCMP knew as early as when Mr. Arar was being detained in New York that there was false and misleading accusations against him that had been conveyed to the Americans. And you repeated that, sir, at least 5 times in your testimony. So will you agree with me? This isn't a misperception on the part of those people who asked those questions that day. It's not a misperception on the part of the people who listened to your testimony that day. This was a straight mistake on your part of conveying that information to us.
Mr. Comartin, I totally accept that I made a mistake in my, and I can only attribute that, Mr. Comartin, to my rush to get before in front of the committee and trying to absorb as much of the 1,200 pages of the report as I possibly could. And I clearly made a transfer of the knowledge that I acquired in 2006 to what I knew in 2002, which was incorrect. I accept that I made a mistake in that situation.
Then the information that you gave us, that these false accusations against Mr. Arar being communicated to your political masters, if I suppose I have to say mistresses as well, but to the ministers in that period of time, was also incorrect, because there was no way you could have communicated that information if you didn't have it.
Well, what I communicated to the minister through the briefings was the information that we had, which was that he was a person of interest, we had exchanged information, and that and so on. And this is why Minister Easter and others have testified that I didn't brief them about, because I couldn't have briefed them because I didn't know that information. So I gave them all the information that I had at the time.
Commissioner Zaccardelli, one of the troubling parts of your testimony was, and it is a problem now for me, you repeatedly, in those 5 or 6 times, or maybe Mr. Holland's correct, 8 times, when you repeated that story, you said that we being the RCMP, had attempted, both while Mr. Arar was in custody in New York and while he was in custody in Syria, we tried to correct the false information. And you did. You repeated that a number of times. How could you have corrected false information when you didn't know there was false information?
Mr. Comartin, that's a very good question. And what I knew is that the members at the time transmitted certain information to the Americans about what the status of Mr. Arar was to the RCMP, which was, and we told the Americans 4 days before he's deported, we can't link him to al-Qaeda. We can't lay a criminal charge against him. We can't detain him or prevent him from coming to Canada. But when the members, I now realize, when the members were telling him that, they weren't actually telling them to correct the record, because the members, I've learned since, when they testified before O'Connor, said that if the Americans had this wrong impression or had this false information, that testimony or that information given to them about not being linked to al-Qaeda should have corrected the record. That's what I was referring to about correcting the record. If the false information had gone, which we didn't know had gone, it should have the effect of telling the Americans, we can't link him to al-Qaeda, we can't arrest him, we can't detain him. That should have had the effect of correcting the false information that they may have had.
Mr. Commissioner, that just is not logical. That doesn't make sense. Why would your personnel, why would your staff be correcting something that they didn't know about? Why would they be talking about correcting anything? Why would they simply not be saying he's a person of interest and stop at that point? Where does the the link with Al Qaeda, him being a terrorist, him being an Islamic fundamentalist or a fanatic? Why would they be addressing that to the Americans unless they knew? And that, Mr. Commissioner, is really my problem. Is there more information that they communicated to the Americans that didn't come out in the O'Connor report and that you've not disclosed to us?
Absolutely not to my knowledge, Mr. Comartin. What took place is the Americans, they've got Mr. Arar in detention. They call the Canadians and they say, what do you have on him? Can you detain him? Can you charge him? So at this point, the response is, no, we haven't got anything to link him to al-Qaeda. We can't charge him. We haven't got any evidence to charge him. We can't detain him, and we can't prevent him from coming back. Yeah, that's all they passed on.
Sir, are you absolutely certain those questions came from the Americans, or was that us being defensive? Was that the Canadian officials being defensive?
No.
Have you looked at the specific exchanges that went on at that time?
I did look. That was my first entry into the file looking at that exchange, and that's contained in Justice O'Connor's report. He clearly states that. And the members themselves, when they provided that information in 2002, they were providing it not with the objective of correcting anything, because they actually didn't know that any errors had been made. This is one of the issues. So they were simply responding to an American request as to whether they could arrest him or whether we could detain him. So they simply gave him what we considered Mr. Arar to be in Canada, regardless of the mistakes of the mislabeling that had taken place. But the members only testified to the question of possibly having a corrective effect when they testified in front of Justice O'Connor. And they said, well, if the Americans were unsure of what we had on him, what we told them at that time should have clearly put them in the knowledge that we couldn't arrest him or do anything with him.
How much time?
Go ahead.
Do you know today who the people were within your force who put Dr. Mazeeg and Mr. Arar on that customs list?
I don't know the specific name, but I know the people that prepared that list. And it's important to remember that list contained a number of suspects that were clearly identified by the RCMP in an investigation as Islamic extremists. Mr. Arar and Ms. Mazeeg were add-ons to that list. So a number of people on that list were legitimately classified as Islamic extremists. The mistake was when they added on Mr. Arar and Ms. Mazeeg that they didn't indicate that those two were only persons of interest. They didn't distinguish that. There is an individual in the RCMP who actually did that, but that person, and Justice O'Connor accepts that testimony, did not believe they were doing anything wrong when they put that person on the list. That's why that issue never was briefed up, along with the other mistakes that were made.
And even after the fact, they never came to tell you. When it became so obvious to any Canadian citizen in this country how damaging that was to them, they never disclosed that to you.
But
never.
Because they didn't realize. No, it never came up. Only when Justice O'Connor brings it all together, Mr. Comartin.
To wrap up this final round of questioning, Mr. McKenzie, please, for 7 minutes.
And thank you, Commissioner, for being here. I understand that yesterday, Commissioner, you attended at a public function and spoke about the Arar case. And I'd just like to read to you one quote from there, talking about the inaccurate information. This was not recognized by the RCMP at the time, and senior officials, including myself, were not informed until the Commission of Inquiry completed its work. All the above information is documented and detailed in Justice O'Connor's report. Now, my friends opposite have talked about the differences, and I would read to you a couple of other quotes from September 28th from the record. One of your answers was, as I explained to Mr. Kotler, this happened at the same time. It is when I was inquiring into what happened in Mr. Arar's case that I learned our investigators were trying to correct the false information that had been conveyed to the U.S. authorities. It is at that time that I was made aware of the correspondence between the Americans and the RCMP investigators. This is then that I found out that false information had been conveyed concerning Mr. Arar. And then on to Mr. Menard again. Mr. Chairman, as I have said, I learned that a mistake had been made and the information concerning Mr. Arar was false after Mr. Arar was imprisoned. At the same time, I learned the investigators had made an effort to correct that false information, but it was after Mr. Arar was imprisoned. Then you went on to say, again in answer to Mr. Menard, when we learned what had occurred, we had discussions with the minister to inform him of the situation, and we began to notify the authorities of what had happened in this case. I think Canadians legitimately would question what's happened here. I know that you've indicated that after reading Mr. O'Connor's report, but I don't see what Mr. O'Connor's report has to do with either one of these situations. I think it was pretty clear to the committee, and I understand why our friends opposite are upset. On September the 28th, you were very clear about when you learned, what you learned, and some of the information that was passed. Can you tell us how that difference comes about today?
Sir, the difference comes about today is because since my testimony on the 28th of September, I have read and reread and reread and tried to inform myself as best as I could. I realized after my testimony that my testimony was not as precise and as accurate as it could have been, and that I had made a mistake. And therefore, I did two things. I tried to come back before the committee as quickly as I could, and I informed myself by reading the report as many times as I could and talking to other people about it. I recognize that I made a mistake in inferring or leaving the impression that I knew information about those mistakes in 2002, when in fact I couldn't have known them. I knew it in 2006, and because from the moment I picked up the report until I testified here, I was absorbed with this report, and I clearly made the mistake of inferring that the knowledge that I was acquiring from the report in reading it in 2006, I inferred that I actually had some of that knowledge in 2002, which I clearly didn't have, and Justice O'Connor clearly states that I didn't have. And one other point I guess I would make is that I guess if I knew that information at that time, or any of my senior officers knew at that time, I think Justice O'Connor, in his exhaustive report, would have probably picked that up and pointed that out, because it does become a very important issue, but Justice O'Connor does not. And so, as I said, I accept that I was imprecise and I made a mistake, and I guess my mistake seems to be constant in my answers, but I'm here to try and correct that as best as I can.
But, sir, with all due respect, and a police officer, I recognize, we keep notes, our staff keep notes. Since September the 28th until today, you haven't gone back and verified with anybody what you had said to us then. You're only relying on what you've read in Justice O'Connor's report to say that you made a mistake?
No, I have reread my testimony. Oh, absolutely, I've reread my testimony.
No, but I mean the notes and the information from whoever. When you had said to us, I learned the investigators had passed on wrong information. We tried to correct it, and we're talking back in 2002. Since September the 28th until yesterday, when you publicly said that you hadn't had the information, did you go back to any of those people?
I'm sorry.
All I'm saying is you were very clear to us on September the 28th that investigators had informed you that mistakes had been made.
But that was incorrect, because they had not informed me.
And all I'm saying is, did you go back to them since then and confirm that they did or they didn't tell you anything? Or are you relying on what's in Mr. Justice O'Connor's report?
Well, I have gone back to my senior officers, and none of them were informed also, because I have talked to my senior officers, and they've verified with me that the reason they didn't brief me is because they were not aware of it, which is consistent with what Justice O'Connor says in his report, that no senior officer was aware, because the briefing up didn't take place, because the investigators, who were separate and apart, and this was never brought together until Justice O'Connor brings all these small pieces of information together, they didn't believe that they were actually making mistakes at the time, and Justice O'Connor accepts that. That's why it was never briefed up.
And are you saying that there was no debriefing took place between your staff before Mr. Justice O'Connor's hearings began? I mean, that was an issue that was pretty prominent in the news. Typically, we would have debriefings and review it. That didn't occur?
Well, the debriefings took place between...
Debriefings between staff?
Yes, there was debriefings about some of that. But I was in the position where I had to be very careful about what was coming out of Justice O'Connor's inquiry, because Justice O'Connor had the mandate to bring all this together and to analyze it. I could not intervene on any one section, because then I would run the risk of intervening in Justice O'Connor's inquiry, and we had to wait till we saw the full picture before we can fully analyze it. It would have been irresponsible of me to intervene just after one or two witnesses. You wanted to wait till the whole picture came out, which occurred when the report came out on the 18th of September.
Okay, I understand that, but Mr. Justice O'Connor wasn't appointed to hold that inquiry until late in the day. between the time of Mr. Arar being released and brought back to Canada and his appointment, there were never a senior staff or the investigators debriefed as to what had gone on in that?
No, because the only thing we knew was the fact that he was a person of interest, that we couldn't charge him, that he wasn't linked to al-Qaeda. The mistakes were not briefed up because the investigators didn't believe that they had made a mistake, and that's what they testified to before Justice O'Connor. So when the investigator doesn't believe they've made a mistake, for example, there is one point that Justice O'Connor talks about, is when the amount of time between when Mr. O'Connor sold his house and went to Tunisia. There's a 5-month gap. The investigators makes in their notes that Mr. Arar departed suddenly from Canada. Justice O'Connor, in his conclusion, says it wasn't sudden. 5 months is not sudden. But that's a conclusion he draws at the end of the inquiry. But the investigator didn't think that that was a mistake. That is one of the inaccuracies. And that was the issue here. These desperate little pieces of misinformation or errors were not seen as errors at the time until Justice O'Connor does a comprehensive audit and brings it together and arrives at this conclusion.
Okay. Thank you. We'll now move to our second round, which is 5 minutes of questions and answers. Mr. Alghabra, please.
Thank you, Mr. Chair. Commissioner Zaccardelli, thank you for coming here. I want to try to summarize what's going on briefly. Commissioner O'Connor's report comes out September 18th, describing a massive failure and violation of RCMP protocols in conveying information, false information to the American law agencies. Canadians were eagerly waiting to hear from you. It took 10 days for you to come on this committee to give us your reaction. At the time, it was very clear, not imprecise, not impression, it was very clear that you said you had found out in 2002 about the sharing misinformation with the Americans, and that you tried to correct it and that you shared it with the ministers at the time. Also, in between, I should mention, between 18th and the 28th, before your arrival to this committee, Minister Day was firm in his support of your office. And in fact, at the time, initially there were reports that the PMO was not so confident at the time, and then they eventually converged and stood together in supporting what you have done and what you've said. After your testimony that you've reported, you've shared that information in 2002 with the ministers at the time. 3 ministers had come to this committee, former ministers, and told us that they were never informed by you. Then somehow, yesterday, you gave a speech to the Economic Club about clarifying these mistakes, which, by the way, I find very interesting, because at the time of the 28th, you said the reason why you have not spoken to Canadians publicly, because you thought this committee was the only proper forum to report to Canadians what you have done and what you haven't done and what your responsibilities are. Yet yesterday you chose to make those statements in front of the Economic Club instead of this committee. Having said that, today you told us you were forthcoming about meetings with Minister Day, even though it took a lot of effort out of this committee to get some type of description from you at the time if you had any political meetings or any meetings with Minister Day. Now today that you told us that you've met with Minister Day, could you please tell us when did you meet with Minister Day and who was present at the meeting?
Okay. Thank you very much, sir, for the questions. Just on your last point, yes, at the last hearing on the 28th, I was not as forthcoming about explaining my meetings. The reason I couldn't do that is because I hadn't spoken to Minister Day, and I thought it was proper to ask permission and talk to him about whether I could give evidence or speak about those discussions. That's why I didn't do it then. Since the 28th, I talked to Minister Day, and he said, yes, go ahead and explain that. So I will explain.
So that's an interesting point. So you are admitting that Minister Day had some influence on how you testify and how your statement should be. That's it's a very relevant point, and I'm glad you clarified it. Go on, please. Can you answer my question, please? I have very limited time, so I apologize. I want an answer to this question. What did you discuss with Minister Day between the 18th and the 28th, and who is present in the meeting? Please, those are the answers that I'm looking for.
Well,
Commissioner,
I have to clarify this point because there was no influence. I simply asked the minister, would he agree to me relating personal discussions that he and I had to this committee. I think that was the proper way to do it. It would be improper for me to relay discussions that took place between me and the minister without his authority, without his permission, which I have done. As I said, I came back on the Wednesday afternoon. On the Thursday morning, I learned that this committee might be sitting. I then write a letter to the minister that same day indicating that I'm anxious to appear to respond to the issue. The very next day, I meet with the minister. We discuss the matter. It's during this discussion that we find out that the committee is sitting on the Tuesday following. And we said, this is
didn't the committee compel you to come and testify?
Not at that point yet. We heard about it, but we had said very clearly the proper place to discuss, the first place to discuss this very important issue was before this committee. And that's why I took so much criticism from the press, because I didn't go out right away to speak to the press. I purposely held back so that this would be the first place that I spoke at. And as it turns out, I wish I'd actually had more time, given that I didn't fully grasp all the implications of the details of this report.
Sir, who is present at the meeting when you met with Minister Day?
Yeah. Mr. Day was present and his deputy minister.
Were there any notes or briefing notes that were shared at the time that you can share with this committee?
No, there were no briefing notes that were taken. It was a very simple, short discussion. The committee's meeting, we both agreed that this was the best place to do it, and that's why we set out to come here. But on Tuesday, you didn't sit because the committee had some meetings, and it was put off till the Thursday. That's the 28th.
Much, Monsieur Menard, 5 minutes.
Monsieur le Commissaire,
Commissioner, you still don't know why the Americans decided to send Maher Arar to Syria. Sorry, could you repeat that? You still don't know why the Americans sent Mr. Arar to Syria. No, I don't know. You have received no further information from the Americans on Mr. Arar? Not at all. But in this struggle amongst civilized countries with our allies, when we have information on or intelligence on a citizen from another country that justifies a radical measure such as sending a person to Syria, where we know what that person would be facing, would it not be natural to inform the intelligence services of the country that he belongs to of this information?
I do not know to this day the basis of the decisions for the Americans to send Mr. Arar to Syria. Justice O'Connor was not able to come to a decisive conclusion on that because, as he said, the Americans did not testify. I have no information that I'm aware of that was shared between anybody relative to this matter, either Syrians or Americans.
donc vraisemblablement,
So, presumably, if the Americans decided to send Mr. Arar to Syria, knowing ahead of time what fate would await him, it is as a result of erroneous or exaggerated information on the part of the RCMP handed over to the Americans. Is that correct?
O'Connor was not able to come to a 100% conclusion as to the basis for the American decision because no American testified. He does state that Canadian information, RCMP information, was in their hands, and he said some of that information very likely contributed to that decision, but he could not come to a definitive decision on that.
Monsieur le Commissaire, je trouve
Commissioner, I can't believe that the Americans, if they didn't have any other information against Mr. Arar that would have linked him to terrorist networks, that the Americans would not have informed Canadian authorities of these facts. I personally find that it is unacceptable for a police officer who learns that somebody is in jail because of one of the mistakes made by other officers would not do everything in his power to have this person freed. I find it unacceptable that that fact was not communicated to the minister, and that is why I ask you to resign.
Mr. Chairman, I have repeated several times today. I've tried to be as precise and as correct as I possibly can. I've admitted that I made a mistake and may have stated certain things that were not as accurate. I did not have any information about the mistakes or the errors that were committed by members of the RCMP, nor any of my senior officers had that until it came out in the report in 2006. Justice O'Connor clearly states that. I quoted Justice O'Connor today. So to say that I had that information at the time that Mr. Arar was in New York or was in Syria is inaccurate.
Très bien que c'est ce que nous croyons à vous écouter la dernière fois.
That's what we had understood when you spoke to us last time. You didn't correct that last time around. You've realized since September how serious this information that was not in the O'Connor report was, but that has been communicated to us by you.
To try and correct the record and be as forthright as I possibly can. I don't think I'm the first person that's ever come before a committee to clarify some issue that may not have been presented in the most appropriate way. I probably won't be the last. I have made mistakes in the past, and I probably will make them in the future. But I'm here to correct the record as best as I can and assist the committee in arriving at its conclusions.
Other final question? Go ahead.
Okay.
Go ahead. Yeah, final question.
Mais quand vous avez dit à M. Cotler,
But when you told Mr. Kotler that when you learned that Mr. Arar was in prison in Syria, you had the file pulled out and you realized that mistakes had been made and corrected. So that in itself was enough for you to know that even though the Americans may not have said anything more than that, it was because of these mistakes that Mr. Arar found himself in this position, and consequently he was an innocent man incarcerated in Syria. And the origins behind that was the false, misleading information in the file that you were made aware of when you had that file pulled out.
I did not learn of the errors and the mistakes and the mislabeling until the report came out. If I said anything that was inaccurate in terms of what knowledge I knew in 2002, I've tried to explain that I was absorbed by the report, and I probably made the mistake of transferring some of that knowledge that I acquired in 2006 to what I knew in 2002. In 2002, all I knew was that Mr. Arar was a person of interest. He was from the beginning right until the conclusion of the report. The other thing that I knew was that we could not arrest him. We could not charge him. We could not prevent him from coming back into Canada. That is all I knew. That is what I was told. That is what I briefed up to the minister to the best of my ability. And we continue to provide that information to the minister to the best of our abilities. That is what all our senior officers knew. And Justice O'Connor clearly states that this information was not briefed up because the investigators believed that this was not erroneous information. It is Justice O'Connor, in his exhaustive auditing of the file, brings it all together and comes to this conclusion, which we have accepted totally, and we've moved very far in implementing his excellent recommendations so that we try to prevent these types of mistakes from ever reoccurring again.
Thank you very much, and we'll now go over to Mr. Brown for 5 minutes.
Thank you, Mr. Chairman. Commissioner, this really is a tragic episode in the storied history of the RCMP, and I'm very disappointed. But, Commissioner, you told Mr. Holland that you were not as precise in your answers as you should have been on September 28th when you testified here, and frankly, that really makes no sense. You were very precise. You gave us a time frame when you supposedly informed yourself. You described learning of the errors, and you even went so far as to give an excuse of a short response time for the misleading PCO briefing, which we now know to be completely false. Now, do you dispute this? And what is your explanation for your false info about the PCO briefing that I asked about on September 28th?
Thank you for that question, Mr. Brown. The question of the PCO briefing, as I tried to explain, and again, I was not as accurate as I could have been or should have been, because that was the best information I had at the time. I stated that we had to prepare the brief within 24 hours. We actually had, I believe, about 9 days or 14 days. What the 24-hour comes in is when I was actually briefed about the fact that my staff was briefing PCO and preparing the timeline. 24 hours before we actually had to produce the timeline to PCO, my deputy advised me we have to give a brief in 24 hours. So I assumed we had 24 hours to prepare it. I was not aware, and I learned later, that we actually had 9 or 14 days that we had actually started accumulating that information. But even that, the fact that we had started 9 or 14 days before, did not enable us to gather all the information that was actually out there that we needed to produce. And that is why we provided the information as best we could, but in an incremental way. So when we did provide the first batch of information, we knew and we explained to PCO that it wasn't all that we had to give them, because we had not been able to physically bring out all that information. So the 24-hour is the fact that I was told 24 hours before it's to be delivered, my deputy says, we have 24 hours to deliver. So I thought, well, how could they give us just 24 hours? But actually, we had been working on it for, I believe, 9 or 14 days, and I'm not sure. But even in that period of time, we had not been able to gather it all, and we advised PCO that this will be coming to you incrementally as best as we could.
Okay, now, you also said that Justice O'Connor found all these facts that somehow eluded you. Now, Commissioner, the info that Justice O'Connor got about the RCMP errors came from RCMP officers. Now, how on earth can it be that the Commissioner can't get info from his own organization, even if you weren't misleading this committee and covering up the truth, as you're now claiming? Now, doesn't this suggest that you really failed in your duties as Commissioner of the RCMP?
Well, again, that's a good question. And, you know, I have 25,000 employees. I have literally tens and tens of thousands of investigations and files that are out there at any given time. We have a system that tries to funnel the most important files, the ones that I need to be briefed on, and at what time, and so on. This was a file that, remember, targeted a number of suspected Islamic terrorists. Mr. Arar is a peripheral figure. He's a person of interest that comes into the file. This is not something that I would normally be briefed on, and so on. So when he does become of interest after he's in prison in Syria, I do start to get briefed on the file. But again, the false information, as I've stated and Justice O'Connor states, is the members who actually produced the false information or the false labeling were not aware themselves that this was false information. It is only when Justice O'Connor brings it all together as in an audit way. And this is normal in a large organization where you have disparate pieces of information all over the place that you don't know what they mean until somebody brings them together when an inquiry or an audit is done. And this is what happened in this case. That's why none of my senior officers were actually aware, and that's why they couldn't have briefed me, because the people on the front end were not aware that these were errors or this was a mislabeling. And that's one of the big lessons from O'Connor. That's why we've put into place rigorous training. We put in rigorous policy in terms of information sharing. That's what O'Connor has done for us, enabled us to really learn from these so that we don't repeat these mistakes again.
Okay. Commissioner, this is very important. I mean, we had a man sent to Syria who was tortured. We have the taxpayers of Canada now potentially on the hook for up to $400 million. And I want to just quote a little bit from what you did in your presentation today. And we need to get past the notion that you were quoting about former Minister McClellan, but we need to get past the notion that heads must roll to have accountability. And sometimes maybe they should. Do you think maybe they should in this case? And then the second part, because I'm sure I'm running out of time, but the second part is you said about, or it referred to that changes in the procedures that have to be in place. You talked a little bit about that, but what other procedures are you putting in place to ensure that this never happens again?
Well, as I said, based on Justice O'Connor's report, we have now a very rigid governance structure, which means that no information is shared outside of the RCMP without a serious vetting and review in headquarters, and then that information is only shared once the most senior officers review that to make sure that all the policies is followed and is complete. So that is a very rigorous and centralized governance structure. We have extensive training now for members to be very sensitive to the fact that when you label someone, especially in a national security area, you can make a serious mistake or it could have serious repercussions if you're not very careful. And this is something that we are taking even beyond our national security area. So there is a very rigid learning process. The exchange of information is very, very tightly controlled. The training is much better now. We've got new MOUs with CSIS. We have a very rigid and very detailed MOU so that we understand what each other is doing. So we have actually put into place and are well down the road into incorporating all the lessons that we've learned from Justice O'Connor. So that's why I believe, although we can never guarantee, I believe we are a long ways down the road to ensuring that this type of mistake never happens again. But I must also come back to the point that Justice O'Connor says about the investigators. He said they were hardworking, dedicated investigators. They made honest mistakes. They did not have any malintent. They did not do this with any intention to hurt anyone. They were doing the best they could in an environment that was very charged and very difficult. And that is why when Justice O'Connor, I believe, is very fair in terms of accountability. He takes into consideration the whole context in which they were operating, and he gives us lessons learned, and he gives us the proper recommendation so that we don't do this again.
Would you be supportive of a parliamentary oversight committee, a committee of parliamentarians?
Well, as you know, Justice O'Connor later this month is going to be coming down with a report on oversight, and I will accept whatever recommendations the government agrees with and goes along with. I've stated in my testimony before Justice O'Connor, I said I will accept any oversight that is imposed or that is put upon us, because I cannot have any diminution of the trust that Canadians have in their national police force. I will support any decision by the government relative to oversight, whether that involve the parliamentary committee or other types of committee or oversight.
Thank you. We're going to move to the third round here, but before we do, I have an obvious question. I think following the meeting on September 28th, you must have gone back to your senior staff and asked for some kind of a briefing. Could you describe any of the briefing notes that you would have been given by your staff, and could you also provide those corrective briefing notes that your staff would have given you to this committee? Would you be willing to do that, sir?
Well, I honestly don't know if there's any briefing notes, Mr. Chair. What I did is when I went back after the 28th of September, of course, I sat down with my staff and with my advisors, and we reviewed what happened. And of course, then it started to come out about, I was advised that my answers were not as precise as maybe they could have been, and then we started again reviewing what was in the report. And so we started examining that to make sure and getting the transcripts and looking at what I said, how that matches against the report, what is the actual information, and so on. And then, as you recall, shortly thereafter, I believe members of the committee were talking with former Solicitor Generals, and there were reports about, well, the Commissioner didn't brief, and the answer was, well, no, we didn't get that, and so on. So that's when we started calling the clerk and started calling the committee to try and come back before the committee. So there were a series of discussions in terms of analyzing my testimony, what was in the report, what was actually took place. But I will check if there's any notes or if there's anything, Mr. Chair. I will certainly provide you with that.
Yeah, no, I'm thinking more. There must have been some kind of an investigation that you would have put in place within your own department to find out what happened. And you're saying there were no briefing notes that you received as a result of this?
Well, we didn't do an investigation. What we did is we looked at what I said, what were the questions, what were my answers, what does O'Connor say, and what was the testimony in front of Justice O'Connor. That's what we concentrated on. That's what we looked at.
Okay. Mr. Kotler, are you prepared to begin the next round?
Thank you, Mr. Chairman. Commissioner, I have some questions that are really straightforward in terms of requiring just a factual answer. I think the answers may even be known already from the public record. Number one, is it the case that RCMP officials, under your overall superintending authority, gave false and misleading information to American officials that, in Justice O'Connor's words, likely contributed to Mr. Arar's deportation to Syria, and that this false and misleading information was subsequently corrected to American authorities by Canadian officials? As you yourself have testified on that.
Yes, I think I would say, to the best of my ability, yes to the first part, in the sense that, yes, we did provide that information, that information that was mislabeled, that was inaccurate. Yes, we did provide that. But
that's all I wanted to know, Mr.
Yeah, but there is a second part to your question about the. I don't believe honestly, we never corrected that with the Americans.
I thought you had stated that the false and misleading information had been corrected. This appears to, now you're saying it had not been corrected. I don't know which version, Commissioner, to appreciate in this matter. So let me go on. Is it the case that the RCMP officials gave false and misleading information to American officials that you never gave to Canadian officials, and that the information was corrected with American officials that was never corrected with Canadian officials?
No, information was given, and this applies to your first question. Information was given to Americans, which our investigators did not believe was false or inaccurate, but which Justice O'Connor, in his report, finds to be inaccurate, false, and misleading. And we did not. So we never provided that information to our ministers because we never believed. I didn't have that information.
Well,
it was never briefed up.
Let me ask you this question, Commissioner. Did you know that the RCMP, in an unprecedented manner, to use Justice O'Connor's words, had supplied the entire supertext database to American officials regarding Mr. Arar and any relevant investigations there too?
I learned that from Justice O'Connor's report.
You did not know that something as serious and as unprecedented as the conveyance of an entire supertext database had been done without your authority and knowledge, though you are the overall superintending official responsible for the activities of the RCMP? This had never been done, ever.
Well, that's right. There's several points to that.
And my answer is just yes or no. Did you know?
No, but there are unprecedented times, and that's why there was unprecedented exchanges of information.
I'm using Justice O'Connor's words that this was an unprecedented conveyance. Let me ask you the next question.
Well,
whatever
Mr. Chairman,
version. No, Commissioner, I just asked you as a statement of fact.
Well, I'd like to answer. I didn't answer the question, Mr. Chairman. I want to be able to answer the question.
Go ahead, Mr. Zaccardelli.
It was unprecedented, and I accept Justice O'Connor's report. If my memory serves me correct, I may have seen one or two briefing notes that made reference to the fact that this extraordinary exchange of information between the Canadians and Americans did in fact take place. But that was confirmed with Justice O'Connor. So I want to be very precise here. I believe I would have heard about that after the fact from a briefing that I would have gotten as Commissioner.
Commissioner, whatever version one takes of your testimony, that of September 28th or that of today, what is clear is that you never corrected the public record, including damaging leaks to the effect that Mr. Arar was a terrorist and, quote, a very bad guy, which Justice O'Connor said had a devastating effect on Maher Arar, even though you knew by your own statement then and your own statement today, and that at least is consistent, that there was no evidence to the effect that Mr. Arar was an Islamic extremist associated with al-Qaeda, that you, as you stated today, said there was no basis to arrest him, to detain him, to refuse his entry into Canada. Yet when all these damaging leaks came out, and Mr. Justice O'Connor refers to 8 damaging leaks, seriously prejudicing, having a devastating effect on Mr. Arar, you never once corrected the public record. Don't you think, as the Commissioner of the RCMP, you had a responsibility when a Canadian citizen was in a place we knew routinely tortured Canadian citizens to correct the public record?
Mr. Cotler, as I've stated previously in my testimony today, Mr. Arar was a person of interest from the very beginning of this investigation. He continued to be a person of interest to the RCMP when he's detained in New York, while he's detained in Syria in jail, and throughout the inquiry. He ceases to be a person of interest to us only at the conclusion of Justice O'Connor's report. So he was always a person of interest to us. Justice O'Connor says we legitimately had every right to label him as a person of interest and to investigate him. That is why I could not say anything about that. And at the first opportunity after the report came out, I publicly apologized for the part that the RCMP may have had in the ordeal that Mr. Arar was subjected to.
I have one last question, my final question. That whatever version one takes of your testimony, September 28th or today, it is clear that you never advised Canadian ministers, as Justice O'Connor says, of the detailed timeline and investigative information that they ought to have known. 2, you never corrected the public record as I indicated today. 3, you did not support the one-voice letter, as Justice O'Connor said you should have, though Mr. Arar's rights had been and continued to seriously be abused after that point. 4th, you did not take pains, though asked to do so as Commissioner of the RCMP, to determine the full truth about a Canadian who was being held in detention. Forget about what you would have been told or what you were not. You did not yourself take the pains. And my question to you is, should a person who is the Commissioner of the RCMP, with all the failures that I have just itemized and others, should that person continue to be the responsible for the activities of the RCMP when there was a clear failure and breach of those responsibilities as I have described them and as Justice O'Connor described?
Mr. Cotler, you've asked me about 7 questions in one question, so I will try to answer as best as I can. You talk about the fact that I did not, or the RCMP did not brief the ministers of these errors or these facts. As I've stated previously, and as the report of Mr. O'Connor states, I could not have advised them because I was not aware of that information. That information only comes out after Justice O'Connor does his comprehensive auditing and review of this file. And as soon as that happened, I did come before this committee and I did issue an apology, as I stated, in order so that Mr. Arar understood that we were sorry for whatever part we played in the ordeal that took place. We did everything I can. I did inform myself. I was told repeatedly, and I passed this on to our ministers and to PCO, that Mr. Arar was a person of interest. He continued to be a person of interest throughout the investigation. We could not charge him criminally. We could not detain him if he came back to Canada. We could not prevent him from coming to Canada. We passed on all the information I knew. I could not pass on information that I did not have, and Justice O'Connor states that in his report.
Thank you. Mr. Norlock, please.
Good morning, Commissioner. Thank you for attending again. The last time you were here, I asked you a question with regard to the processes that you were taking in order to make sure that this would not happen again. And I think I referred to perhaps sharing best practices with other larger police organizations, whether they be in Canada or elsewhere, and I perhaps didn't say elsewhere. And we do have other organizations within Canada. So today you have told the committee that you have put in place actually a structure whereby the circumstances surrounding Mr. Maharar would not occur again. And I'm wondering if you had anyone else from outside your organization take a look at the retooling or the implementation of that plan to ensure that perhaps a pair of fresh eyes may be able to shed more light on the situation. And so I guess my question is, did you in fact go elsewhere to see that, to get some information or to ask opinions? Yeah. And if so, who would they have been, and what kind of information exchange did you have?
Again, thank you very much for that question. Yes, we have gone outside of the RCMP. In particular, as I stated earlier, we have renewed our memorandum of understanding, for example, with CSIS, where we now are much more in tune and work with them much more closely in terms of the work that we do, in terms of understanding our mandates much more clearly, in terms of making sure that our files, our work are synchronized, our work is synchronized. We have learned from them their best practices in terms of managing sensitive information, how do you exchange sensitive information. We've also gone outside of Canada. We've gone to Great Britain, for example, and as you know, Great Britain is being challenged in a lot of ways relative to national security issues. So we've looked at the Met. We've talked to the Met in England. We've talked to people from MI5. We've gone to other countries. We've talked to Australia, New Zealand, and so on. These are countries and other countries that are facing the same types of challenges in terms of terrorism, and how do you bring security agencies and law enforcement agencies in a seamless integration to work on these files. And we've exchanged information, we've looked at best practices. I've sent a team around the world literally to look at best practices, and we've incorporated that along with Justice O'Connor's recommendation in what we have done in terms of policies and practices and training and so on. And I am again, I can't guarantee anything in this business, but I think, and Justice O'Connor actually said that our policies were actually very good even before 9/11. I believe we have a very, very good system now that would stand the best scrutiny of Justice O'Connor or anybody else and is comparable, if not better, than a lot of countries. It has to be, because we've learned a lot of lessons from here. A lot of people have been hurt in this situation, and I myself have not gone through some easy weeks since my last testimony. If there's anybody who's taken some serious hits because of my information that wasn't precise, it has been me. So we've all learned, and this is what I'm trying to do. I'm looking forward, not forgetting the past, but trying to correct those mistakes, and we've gone around the world looking for those best practices.
There are a couple of small questions in here, but when I say small, they may be short questions, but they sure aren't small in scope. You referred to in your testimony here today that you cannot, the RCMP cannot, afford the diminution of the faith of the people in Canada, that Canada's most senior police force is not at 100% pristine pure, as much as can be expected of any group of men and women. And that we could not afford the diminutionization of that. I guess my question would be, when as a police officer, some 37, 36 years, when we see, as a result of the testimony that you made before this committee, when you see the repercussions they have both on the institution of government and in particular the co-relationship that your police force has with that. The fact that you did make some, as the top officer, you did make some changes. Do you think perhaps organizationally there needs to be additional changes as far as personnel and their current responsibilities? And going further from that, or further with that, and carrying on from what Mr. Menard...
Wrap up, your time has run out. And Commissioner, if you could give us a short answer.
Yeah. But just going further to what Mr. Menard said, when one realizes that they've done something that results in something having gone wrong, should they not go directly to the people who they've misinformed? In other words, perhaps when you did notice that you did misinform this committee, would you not have thought a memorandum to the committee chair immediately upon that, and so that we wouldn't get the news from another public function that you were at?
Well, as you know, sir, I immediately started calling my office started calling the clerk, started calling the ministry to try and get in contact with the committee, but the committee had other work and so on. We were hoping to get on before other witnesses got on. I wrote a letter that's dated the 2nd of November, and it's more than a month ago that I wrote the letter. So we tried everything I think we could, but we were working closely with the committee to try and accommodate each other. So I believe I did everything I could to try. I recognized that the matter needed correction immediately, and we did take all the steps that we could.
Chan, please.
Mr. Secretary, on September the 28th, you make some statement that is that have huge implications. You're so sure of what happened on this case. I believe that there must be some circumstances that make you make those statements because of the implication, and things wouldn't just appear, just happen. There must be some circumstances that make you make those kind of statements. Okay, and now I want to get down to the motive and under what circumstances that make you make those statements that are now you try to deny that they're facts. First, between September 28th and September 28th, you were recounting your meeting with Minister Day. You went as far as meeting Minister Day on the 22nd of September on a Friday. Can you tell us who's in that meeting and what is talked about, what is being discussed in that meeting? And for any other further meeting, you have Minister Day.
Well, Mr. Chairman, I'd like to answer the first part of the question because, you know,
Mr. Secretary, we don't need answer to that, but what we need, we need answer to what was being discussed with Mr. Day and who was there and any other meeting you have with Mr. Day before the testimony.
Mr. Chairman, as part of that question, certain things were said, and I believe I need to address those. The first part is in terms of the testimony that is in question about the 28th. I mean, you know, I've thought a lot about that, you know. I mean, the consequences have been severe for me. I don't think I would have done that on purpose. As I said, I tried to give as best an explanation as I could. I tried to absorb the best information. But I clearly made a mistake in transferring what I learned and what I was driven with in 2006 from the report, and I implied and stated that I may have had that in 2002, which I clearly did not. And it has been very difficult for the last few weeks because of that. I'm the only one that suffered as a consequence of that.
No.
Now, but in terms of your question, Mr. Chan, and I appreciate the question, on the Friday, when I met with the minister, the only other person that was in the room was the Deputy Minister of Public Safety and Security, Madame Suzanne Hertzebise. The only thing that was discussed was the appearance before this committee, because we both knew then on Friday, we knew on Thursday that the committee was possibly going to be meeting. We knew on Friday that we would probably be meeting, the committee would be meeting on Tuesday, and therefore we said that is the appropriate venue for us to respond to this matter. That is why I did not go public with the media, and that's why I was severely criticized by the media, because they said I should have been responding. And they actually, they asked me questions on the memorial service on Parliament Hill. We both decided that the best venue would be...
What, in the discussion with Minister Day, do you talk about any communication strategy or what you're going to talk about in this meeting?
Absolutely none.
Okay, thank you. Also, between September 18 and September 28, Did you have any meeting or meet or communicate in any way with senior department officials from PSET or any other government department concerning the report, or your statement concerning the report either to the media or to this committee?
I believe, and I don't know if I can be exact here, but I believe I talked to the Deputy Minister of Public Safety, and I expressed a desire to try and find a venue as soon as we could for me to speak on this matter. I am not sure if there was any correspondence or dialogue with anybody at PCO, at the Privy Council office. But I did say, I said to a number of my friends and some other people, I was very anxious to deal with the matter because it was a very high-profile matter, and I wanted to appear and speak about the matter. But none of these people in any way said anything to me or gave me any direction or any advice, because they don't give direction or advice to the Commissioner of the RCMP. And in my discussions with the Minister, never did he in any way indicate that I should do anything or say anything or direct me in any way.
And between September the 18th
your
and...
time is up, Mr. Chan. Sorry, we'll come around to you. We want to give everybody a chance here. Mr. Hahn.
Mr. Zaccardelli, today you said on October 5th and 7th, 2002, respectively, RCMP staff advised the FBI and the RCMP could not link Mr. Arar to al-Qaeda. On October 11th, you were formally briefed that Mr. Arar had been removed to Syria by U.S. authorities, that you had shared, RCMP had shared investigative material with them, and that Mr. Arar was considered a person of interest. Surely the fact that the U.S. deported him to Syria would suggest that they certainly considered him something more than a person of interest, and that it would have behooved you or somebody in the RCMP to have taken action at that time, either on your own authority or in coordination with government authorities, to try to protect the rights or to intervene on behalf of a Canadian citizen. Shouldn't that have not twigged him as something much more than a person of interest in somebody's mind?
Well, as you rightly stated, we provided the best analysis of the information or intelligence or evidence that we had relative to Mr. Arar. They asked for that. We told them what our situation was. We gave them that information. They subsequently took the action to remove him. We don't know totally what they relied on, and just as O'Connor says, they most probably relied on some Canadian information. We did try to inform ourselves from the Americans of how they came to make this decision. We did not get any response from the American officials. And I believe as one of the Solicitor Generals, I'm not sure if it was Mr. Easter or Mr. Macaulay, in discussions with Attorney General Ashcroft subsequent to that, where Mr. Ashcroft stated to the Minister that the decision, they used various sources of information to make their decision.
But before, I mean, surely you obviously knew before the O'Connor report in 2006 that, you know, something else had gone on back there. And I'm a little bit incredulous that a police officer with 36 years' experience could make such a mistake of transferring knowledge gained in 2006 to a situation in 2002 in a matter that serious, not having been a police officer. But I would think that I would have gone back and checked my notes, which surely I or somebody else under my authority would have kept at the time to verify whether the knowledge gained, you know, in 2006 was really knowledge that I had in 2002. I have a hard time accepting the fact that you could make such a mistake of transferring knowledge to 4 years previous.
Well, as I said, you know, as soon as I came back, I absorbed myself in the report, and I read the report completely. And when I walked into this room on the 28th of September, I had as much knowledge as I was able to absorb. And I obviously did state certain things that were not accurate, and so I said I apologize for that.
Police officers keep very good notes. I know that. And on a matter this serious, I would have certainly gone back to my notes from that period and found out whether the knowledge I just gained was knowledge I really just gained, or I'm transferring back. I'm sorry, I'm just a bit incredulous that a police officer with your experience would make that kind of mistake.
But I didn't have any notes back then. The only information I had was in the report. back then, at the time, when I involved myself, once Mr. Arar was in Syria, I asked what had taken place. Well, who was Mr. Arar? And I'm told that he's a person of interest. I am told that we've exchanged information, investigative information with the Americans. I am told that we advised them that we couldn't charge him. That is what that's what I was told, and that is what we subsequently told to the minister and briefed up. It's only when I read the report that I found out, beside that, there were some errors that had been made previous to his detention in New York by investigators, and Justice O'Connor says those mistakes were honest mistakes, and that's why they weren't briefed up, so they never came to me or to my senior officials.
Well, I think you can appreciate why on both sides of this committee we find that a little bit hard to believe.
I can understand that, sir.
Half a minute left.
Just a very brief question. I know what the answer is going to be, but I want to get on the record anyway. Ms. McClellan said something about perhaps it goes to something more important in terms of the culture of that organization. Is there a problem with the culture of the RCMP?
I don't believe there's any problem at all with the culture.
For which I have the utmost respect.
Yeah. Well, again, sir, I go back to what Justice O'Connor says. He says this team was a team of highly experienced investigators, extremely dedicated to doing their work. They were put into a situation in a context that was literally unknown, unprecedented. And by the way, this is the same situation that's been faced by all democratic countries around the world. He says they weren't the best trained in this area, although they had other expertise. But he understands the situation, and therefore he balances the gravity of the mistake. But he recommends how we can improve, and that's what we're put into place. These are highly skilled, dedicated members who gave everything they could for this investigation. They did make some mistakes, and Justice O'Connor recognizes that. And I, as the Commissioner, have to take that into consideration when I decide what to do with those members relative to those mistakes. I also am very much aware of the culture of the organization and what has to be done to move this ahead. And that's why, as I said, I have taken the recommendations and accepted them wholly. We've put most of those into place. We've gone around the world to learn best practice and learn from each other. That is what we've done, and I'm committed to continuing to doing that.
I agree with your assessment of your members.
Yeah, thank you. Now, we have gone through our entire rotation. And I just have a question for the committee. Do all the political parties still have another question, a wrap-up question? The Bloc do, the NDP? Well, we're going to have to maybe have a 2-minute round then in order to so. Well, we don't have 5 minutes. So what, do we want to end it now?
No, Mr. Chair, I have a question. I'm requesting my 5 minutes, please.
Continue
That's in accordance with how we always do.
So you'll deny the other political parties their time.
This is how we've always done it.
No, if we get close to the end, we all share the time. Okay. I'm sorry.
Thank you. He says they're saying they're accepting that I get 5 minutes.
Okay. All right. Go ahead.
Thank you, Mr. Chair. I want to start by saying that it was made clear through testimony today that, in fact, there was political interference. That, in fact, what you have stated to us is that you had to get permission from the minister about what you could testify about. Which is, again, yet another major contradiction from what came before. But what I want to ask is a couple of questions. A couple of questions, if I could. I'm moving on. I made my point on that. I have a couple of questions.
Yeah, we have a point of order, so we'll just hold off for a second here. Go ahead.
Well, first off, I think you've interpreted something totally different than what was said.
This is a point of debate. That's not a point of order.
Yeah, that's right.
That's a point of debate, Mr. Chair.
Well, but you've made a point that there was political interference. I don't think we ever heard
I'm
that
allowed
story.
an opinion. This is a debate, and this is not a point of order. What's your point of order?
You're trying to put something on the record that wasn't said.
Okay. Go ahead.
If I could, between the period from September 18th going forward, can you tell me if you had any consultant advice on how you should handle this matter in dealing with the media or dealing with this committee? Yes or no?
Mr. Chair, I would like to come back to the first point.
No, I only have 5 minutes. I only have 5 minutes. Can you please answer the question that was posed to you?
Mr. Chairman,
my answer is... Can you please, Mr. Zaccardelli, answer the question that was posed to you?
I made it very clear on the 28th of September, and I made it clear today, there was never any political direction or influence on my decision when to speak or how to speak or what to say relative to this matter. So any suggestion of that along that line is totally inaccurate.
Well, you
Mr.
contradicted
Chair.
yourself on that, but I have a question. I'd appreciate if I could get an answer. Did you receive consultant advice on how to deal with the media or this committee any time from September 18th to the present? Yes or no?
I received advice from a number of sources in preparation for my testimony before the
including
committee.
Consulting firms?
Yes, I did.
Okay. Are you willing to provide this committee with a complete copy of an agenda or schedule that your office kept that would show all the meetings that were held between the release of the report on the 18th up to the testimony on the 28th? Yes or no?
A schedule of what?
Well, your agenda, your calendar, between the 18th and the 28th. Are you willing to provide the committee with that? Yes or no?
Well, Mr. Chair, I will take legal advice on that point, and if I can provide the agenda, I certainly will do it.
Are you willing to provide the committee with any phone logs you may have been kept from the period of September 18th to the 28th? Yes or no?
Mr. Chairman, the same answer applies.
Are you willing to provide committee with all correspondence you received, including emails that have been circulated between your office, senior officials of the RCMP, senior official and political staff at PSEPC, Minister Day, the Prime Minister, or any member of the PMO, and any outside third party, such as an advisor and the consultant, relating and concerning the Commission of Inquiry report between the 18th and the 28th?
Mr. Chairman, my same answer applies to that question.
Yesterday, you gave a speech at the Chateau Laurier, which touched upon, among other things, the testimony you were going to give here before today. Can you tell me who was made aware that you were going to give this speech? In particular, was Minister Day or anyone from his staff or the Prime Minister's office or any outside advisor or consultant aware that you were going to make this speech?
Very shortly before I gave the speech, I sent a copy of my notes to the department, as I usually do, and to PCO. It was literally within a half an hour of me giving that speech.
So they were made aware then of the speech yesterday?
Yes.
Okay. Did anyone else see a draft of your speech before it was delivered? If so, who? Were there comments on the draft? If so, what were the substance of those comments?
Well, you know, Mr. Chairman, I talked to a lot of people about getting ready for notes.
This is a big speech. You would remember who you talked to. Who did you speak to on this speech and its substance?
Mr. Chairman, I spoke to a lot of people.
Did those people include people in Minister Day's office or the PMO?
Give the
no, to the answer to that specific question, no. There was nobody from the Minister's office that had anything to do with that speech or PCO.
Was the decision to give the speech yours and yours alone? Was the speech made in conjunction or on the behest of anyone? If so, who? In particular, it would be Minister Day or anyone from his staff or the PMO or any outside advisor or consultant involved with the decision was involved with the decision to deliver that speech?
The only person that had anything to do with making that speech was myself. I was asked by the Canadian Club if I was willing to make a speech. I said yes. I did not consult anybody else in government relative to making the speech, and it just happened that the 2 days, by coincidence, were back-to-back.
Other than the fact you made them aware you were going to make the speech?
Yes.
Mr. Holland.
Yes, it was coincidental. I had been trying to get back before the committee, and actually the letter, I had sent the letter requesting to come to the committee, I believe, before I actually accepted the date. And it was only until very recently that it was confirmed what date I would be coming here. So it was simply coincidental that the two were back-to-back, Mr. Holland.
The bloc gave up their time. So, Mr. Comartin, a brief question.
Thank you, Mr. Chair. Commissioner, you were here the last time. You led us to believe a certain set of facts, and I was critical at that time that you had not reported to your ministers. As we now know, you didn't have that information to report. Where I'm now critical is of you and the officials in the department, the force, in this sense. As I said earlier, there wasn't anybody in this country who wouldn't have appreciated the significance of those false accusations, especially in the period of time that we were talking about so soon after 2001, after 9/11. Do you not have any sense of responsibility as the Commissioner to take discipline? Is this not a serious enough case that people did not report those false accusations to you, you found out about them through the O'Connor report? Is this not one of those cases where simply changing the procedure, which Justice O'Connor, quite frankly, found was pretty good? That's not where his criticism was. It was in the application, or more specifically, the non-application of the policies by your staff, by your frontline staff. And is this not a case where perhaps their immediate supervisors, rather than being promoted, as we understand a number of them have, that there should have been discipline?
Mr. Comartin, that's a very good question, and I would like to take some time to answer that.
Let me, Mr. Zaccardelli, I just want to throw this in. Don't give me former Minister McClellan's answer. I already told her I didn't agree with her on that one. So,
your final submission, just a brief response.
Well, the response may take a little bit longer, but I won't get into whether heads should roll or not. That's for another day. But we have to talk about, when we talk about mistakes that were made, there are, first of all, there is a document, the lookout document, which contained a number of people on that document that were legitimate targets of Islamic extremist investigation. Mr. Arar and his wife were added on to that. They should not have been. If they were, they should have been identified. That is the first mistake that we're talking about. But, you know, in Justice O'Connor's report, he clearly states that after that lookout was put out, Mr. Arar does travel back and forth twice to the United States and nothing happens to him. He also states in his report that he can't determine whether or not what use the Americans made of that statement. The other errors, if we want to call them, are things like there's a statement that is made, as I said before, that Mr. Arar sold his house and left for Tunisia, and we describe that as having been done suddenly. Justice O'Connor, when he analyzes that 3 years later, says, no, you shouldn't have described that as suddenly. There is another mistake in the sense where the investigators say that Mr. Arar was actually in Washington on the 11th of September 2001. He wasn't in Washington. That is a mistake. So the other mistake is that when he had the so-called meeting here with one of our main targets at that cafe, the investigators say that he came from Quebec City for the meeting instead of he was actually here. So individually, though Justice O'Connor says that the members didn't believe that individually that was an error, that was a conscious error on their part. But what if I can just finish, Mr. Kumar, at the end when he analyzes this, when he does his extensive audit and brings all that together, he comes to the conclusion that those small errors taken together could have created an inflammatory impression or created the impression in the Americans' minds that he was a more serious person than we actually, and I accept that. I accept that totally. But then he says in his report that they didn't do this intentionally. They didn't have the right training. The organization hadn't given them the right training. So he puts what they did in context. And I'm grappling with how do we deal with somebody who makes an honest mistake that a judge after 2 years...
It doesn't tell you, Mr. Zaccardelli. That's what the problem is.
We're running out of
time.
They
did not report it to you. Okay. That's where the big mistake was.
Because they didn't believe it was an error.
Okay, we'll have to end this. We have to give everybody a chance here. 2 minutes.
I'd just like to make it perfectly clear, Mr. Holland, you've tried to put on the record that there was political interference. I would like the Commissioner to make perfectly clear to Mr. Holland, who doesn't understand that what you said was that you did not receive direction. He seems to be more concerned about a period of time in September than he was in 2002, when his minister should have been asking the hard question. Was there any political interference, just very clearly so that he understands?
No.
Thank you.
I appreciate your coming before the committee. I thank the committee for the questions. I'm sure that we've all been informed of it.